Okay, so good morning. And so for many of you, you're unhappy people. If you're listening to this, someone told you about our Social Security Disability Seminar that we did, Josh Scanlon and I, about retirement and how the interrelationship between Social Security and planning and then winning. So I'm a disability attorney, and I'm just giving you guys an update. I think in general, you have to be mindful that Social Security has made it a lot tougher to win disability. So at least the way that they decide cases. So in terms of how we usually look at this, anyone can win disability if they've paid into the system. That's basically the benefits from your W-2 or you paid in through self-employment. But it's your money. But the problem is that if you're under 55, the judge is just, I think in some respects, signing off decisions by the Social Security Administration that are saying that you can work no matter what you testified to, and even if your evidence is pretty strong. So 55, the rules change, and you just have to show you can't do your past work, your past relevant work, 15 years, but going back. But if it's before 55, then it's any job. So they're going to find some jobs for you most likely. And then on appeal, if you do have a strong case, which means lots of your doctors say you can't work full time, basically, then the sweet spot, which Josh and I want to do this again, the sweet spot is after you get your law judge decision, you go to your hearing on video or phone or in person without a lawyer or with a lawyer. So the lawyer sees you lose, you get the paperwork, unfavorable decision, they say, we're dropping you, we're not appealing. You have an opportunity to ask for an extension at the next level, appeals counsel. 2, add in new medical information that clarifies maybe some issue that the judge was confused about or didn't think there was enough evidence. And that judge is going to have to read the records at the appeals counsel level and articulate, if they follow the rules, why that information doesn't change your case to the point where you need to be remanded. So basically, it's the sweet spot. When I say sweet spot, it's an open door to add in letters from the doctors that really care about you and that know you, the treating physicians that say, for example, this would be a great statement. I read the decision of the judge. Medically, he's not considering the things that are important. These are the things that are important. These are the things that existed before the hearing. With the law judge, these things still exist, and that here's some new testing to prove that the doctors relying on objective findings, objective testing, and then all of that goes back. It relates. They use the word in federal court as relating back to that doctor is relating back to your previous conditions that relate to what he's seeing you after your law judge decision that says unfavorable. So 60 days after you get that letter in the mail, plus 5 days for mailing, and then you can ask for an extension by writing the appeals counsel a quick letter saying I want 25 days to add in new evidence, which will give you, roughly 85, maybe 90 days to see your doctor again, explain you lost, explain what the judge didn't think was persuasive, and then you can go and fix that, which is a really good thing, because if your doctor will take the time to address the opinion, do some objective testing, and then write a letter that clearly relates back, referring to your condition existed before the law judge, and then now it still exists, and here's the evidence, you have a chance to win on appeal. But if you don't, I call it pack the case with new, clearly relevant information as to your limitations, both physical and mental, you are going to have difficulties on the appeal. Now, there's always a chance that the federal judge will remand it, and so it's worth appealing it. But the ultimate posture of the court is if substantial evidence exists to support the ALJ, the law judge, then they will just affirm, which means they'll agree to the law judge and they won't remand it. So you need new information to say, look, the law judge might be the greatest law judge on earth, but that law judge, he or she didn't have this new information from my doctor that clarified things that further supported my case. That is the sweet spot secret. Right after unfavorable, you're sad, you lost, but you have an open door to go back and fix some things that in the most favorable light to you will be considered and be reason for a remand, and then that'll give you a chance to go back in front of that law judge. So that's my update for today, and I'm glad you guys are watching the videos, and some of you guys have reported you've won and got remands from watching my videos, so I'm so thankful for that, because basically that is the motivation for why Josh and I are doing this seminar, to help you. It's not that difficult, but there are some pieces that you have to follow through on. So let me know in your comments what you think, and also let me know whether you have been successful, and let me know, for example, today I am helping someone find the short form on the federal court website to file an appeal. Most of these forms are pretty simple and they're easy for you to fill out, and you can always call the clerk of the court on a federal court appeal and have them help you if you don't understand, if you can't get a hold of a lawyer. If no lawyer wants to call you back, you still have hope. You can still follow through, and then once you get the appeal situated properly at the federal court level, you can hire a lawyer later. So in the meantime, just don't miss your deadlines, and don't skip the lawyer.